I work in the sex crimes department, or division of the DA's office at Lake County. And if you see Gigi, she'll find it both ways. She'll be fine. I've been employed, I've been a deputy DA for over 12 years now, and I've been working at the sex crimes division for over 5. Prior to becoming a DA, I was a victim advocate like yourself, and now I went to law school paralegal, and that's kind of the direction it all went. And I work in the sex crimes division as well in the victim advocacy program. So I'm very familiar with what you do. I really am thankful for what you do, and I know it's not easy. It's very, very hard, but it's very, very important that we have you out there for our victims. When I was an advocate, there were many times I thought, oh, you know, what am I really doing? Am I really helping? And you are. I really realized how important I was for those people who maybe were too shy to talk to the DA or the attorney or to the cops. And, you know, they could do so with me there, or even just knowing that someone was there to support them. So, again, very, very important what you do. Can you hear me back there?
Yes.
Yes? Okay. All right. I'm a little bit tired, so bear with me. So today I want to talk to you just about the criminal justice system. What kinds of things can a sexual assault victim encounter once they make a report? What happens? I'm going to talk a little bit about the law, but I don't expect everybody to memorize it and know automatically what I'm talking about. I'm just kind of throwing some stuff out there just to kind of give you guys an understanding of background information about it. Last time I came to this, we have some lawyers in the audience. Do we have any this time? No? Okay, good. Are most of you? That's questions. No, kidding. Are most of you advocates or what? Or psychotherapists? What's the background here in the room? How many of you are just volunteers, first time out, and how many? Okay, so we're going to start with just a general understanding of the criminal justice system, and we'll go from there. Okay. Feel free to ask questions as I'm going along. There's no such thing as silly questions or bad questions or anything like that, because I don't really know how much to talk about in these subjects. So when I hear your questions, we can kind of make sure everybody's on the same page. Okay. All right. So you guys have in front of you this handout that talks about sort of the criminal justice system, and it's really complicated with all the boxes. So hopefully we're going to walk through it so that it doesn't seem as complicated for you when you're with your victims, okay? So how do we initiate a criminal case? Does anybody know? How do we start a criminal case?
File police report.
File police report, yes, absolutely, because it doesn't get to us unless somebody goes to the police, right? So oftentimes we get calls from people who say they want to report sex crimes or something like that, and we say, "I'm sorry, we're the DA's office. You know, we don't investigate. Our job is not to investigate. We don't take reports. We just sit. We rely on the police department to to do the investigation, to figure out what evidence there is, and they present it to us. Okay. So we really start off at the police department, okay, making of that report. You may have somebody that calls that has not even yet made a report, okay? So it's important to understand what the things that they might encounter when they make a police report, okay? So a case goes either somebody calls the police, either a witness or the victim herself calls the police, or they go to the police station, okay? The police is required to take a report, okay? If they start, telling the victim, well, that sounds like a civil case, we don't really do that, you can make sure that the police officer who's behind that counter, who may be tired or whatever the case is, make them understand they must, by law, take a police report, okay? When they take the police report, they're required to ask the victim questions, okay? And that's what we call, the investigative process. You have to find out what happens. And most of the time, the police departments nowadays will ask the victim, hey, are you comfortable talking to a male? Would you prefer a female? You know, those types of things, because the idea is that we want to make sure we elicit as much information as we can so that the report then can go to the detective. And I'm sure you're going to have detectives and officers come and talk to you about it, but I just want to really briefly talk about that process. So during that reporting period, they're going to be asked questions, detailed questions. What happened? You know, we're going to talk about penises and vaginas, okay? And oftentimes that could be very, very embarrassing or very difficult for some of the people in our community to talk about this explicit details, okay? So you can prepare your victim, or as I now like to call them, your survivor, for that, okay? It's not because we're trying to embarrass them, we're not trying to re-traumatize them or anything like that, but there's a lot of things that we need to ask about. We can't just say, I was raped, and that's the end of it, okay? So, the report is made, we're going to ask details. The cops are trying to find out what? They're trying to find out just the basics. Who? Do we know who it is? Who's the perpetrator? What happened, right? Why are you here to file a police report? When did this happen? Okay. How did they, you know, was there a knife, you know, used? Was there force? Was there no force? Was there a threat? Well, how did this sexual assault occur? Okay. They're not really going to try to find out why. That's really not our job to find out why this happened or why someone commits a sexual assault. But some of the questions are sort of, you know, may delve into that kind of, you know, motivation. What is the motivation? But ultimately, for a criminal case, we're not required to prove what the motivation is. Okay? Does that make sense? You know, I'm not required to prove why somebody commits rape, just that it happened. Maybe motive may be, I was jealous, or, you know, I was attracted to this person. Whatever the motivation is, that's different than explaining to the jury why this occurred in the first place. So once the police officer takes the report, that report goes to detectives. Okay? Most detectives don't work during night hours or early morning hours. So you're gonna have a survivor that's not gonna get an immediate response. They're just gonna get a piece of paper that says, you made a report, here's your phone number, here's your rights. Did you have something to say? No? Okay. So police departments are required to give notification to the survivor about the rights that they have, what we call the Marsy's rights, right? They, you know, what their rights now are as victims. And for the most part, their rights are, hey, I have a right to have my case investigated, I have a right to be kept, given notice of what actually is going to, you know, what's going on with my case. Are you going to present it to the DA's office? Are you going to arrest somebody? If we do arrest somebody, and that person is put in jail, if that person gets out for some reason, either they made bail or something like that, that person has to know, a right to know that, so that they can prepare if the guy bails out, that, you know, they may show up at their front door and knock on their door. So they have a right to be aware of that. So the case, so you start off here. The patrol officer takes the report. If we have a situation where there's a sexual assault team that goes out, that's even better. We get a lot better information from a SART team, response team. But I don't really know of too many cases that come to us that way. Most of them are initiated by the police, and the police then take the victims to a sexual assault, you know, examination place, like go in the center. Most of the time, you're going to have some sort of examination conducted. If the crime occurred within 72 hours, sometimes they may take an exam even beyond that period, because there are some studies that sometimes we get lucky and we can get some physical evidence, or, you know, things like DNA, sperm, that type of thing beyond that 72-hour period, but that's really up to the nurse that's experienced, or if there's a specific reason why we're requesting a sexual assault exam. Okay? So during the sexual assault exam, the police officers are not there, but they may be monitoring the interview from a different location. I have responded to sexual assault examinations, not the actual physical examination, but the interview process where I can see via TV, closed circuit TV, what is being said in the interview. That interview is, and examination is always documented. We have protocols, state of California protocols for that, and that report is made, okay? If we don't know of a suspect, we don't know who it is, the victim can't identify him. Either maybe she was highly intoxicated, doesn't remember anything, maybe has no idea, maybe just woke up in her car naked, or you know, it happened on the street and somebody sexually assaulted him or her, right? We're not going to know who the perpetrator is. Hopefully, through the examination process and the collection of physical evidence, maybe we can determine who the perpetrator is at a later time. So if we cannot identify the who, right, because that's one of the questions we ask, who, what, where, when, then you're going to have a survivor who may not go anywhere after that, or so it may seem like, okay? So you're going to have to, talk to your survivor about that. Okay, we've taken the first step, we've done the report, we made a report, we've gone to the sexual assault examination. We don't get immediate test results, okay? That's only happens on television, right? When they immediately know somebody's DNA and they can identify it. I wish it were that easy, okay? So, you're not going to get that immediate gratification when you're with your survivor or when you're talking to your survivor after they've made a report. It may take weeks, it may take months to even get a profile, a DNA profile, okay, from whatever is collected during the sexual assault examination. Sometimes, if there's enough DNA collected, oh yes?
When they're getting interviewed, do they know that they're being recorded and stuff like that? I mean, that's all.
Yes. Most sexual assault exams the places I've dealt with always start off the interview, is it okay we're recording? Most of the time, however, I think people are so nervous and traumatized, they're not going to really realize that it's happening because the camera is hidden. You don't really see it. I know they're told, and I believe most of the centers get permission, although they may not remember after the fact. I don't know. For children, I don't think we tell them. I don't think we tell the children. We just have them in a setting that's comfortable for them, and then we just go ahead and start the interview. So, but for most adults, they do, at least the organizations that I'm familiar with do notify them.
And then who has access to that after the fact?
So women's centers are very, very good about making sure we protect the privacy of our victims. I know that they will only respond to any request for that video via subpoena. Even myself, I have to subpoena, get a court order before I can see those interviews. Okay, so it's not like they're just out there going on the internet, or you can find them on YouTube. They're very carefully kept and only disseminated to the people that absolutely have to know. So I subpoena those interviews, and then I have to share it with the defense, but that's it, okay? Did you have a question?
Just a comment. So when the interviews happen that get recorded, usually the ones where you're 18 or over, they don't necessarily record those. There has to be some sort of kind of reason why they would record that. That's not normal as far as I know. Like, there's some reason that they would have to do that. The kids' interviews all get recorded. Why? Because they want to use that interview the one time. They don't want to have to re-interview that person because they're a minor. On top of the fact that what has been the practice now is that kids are notified that they're being recorded and that they're being watched in another room by detectives and advocates. They're usually called multidisciplinary interview centers, MDICs. I was privileged enough to go in and be the victim advocate at the MDICs before. But yeah, the forensic interviewer, they're a social worker who has been trained to interview children about their assaults or the intimate partner violence that they went through. And then they disclose, either we're in a room with a two-way kind of thing going on, or we're in a room that has the camera, like the video playing in another room. And they let them know, at least the centers that I've been to have let them know, hey, just to let you know, these little hanging things are mics, I'm wearing a mic, people are watching you. But you know, essentially, they do remind them though that their parents are not watching, because usually parents come with the kids, not always, but they usually do come with the kids. And then, you know, they're always worried, like, well, my mom's, I saw her come in here, you know, I know she's somewhere in this building. Is she in the building where the room's, you know, that I'm being watched in? It's like, no, that person is not in the room. Yeah.
Okay, that's good to know. I'm not familiar with this now telling the children. As far as I've seen, the cases that I've seen, they just bring in a child. But we have those interviews done by someone who's trained specially to talk to children. And that was a result of years of research, of litigation, involving the McMartin trial. It all began back then in the 80s when there was a daycare center where all the children accused one of the caretakers of being sexually molesting them, and it led to their ultimate acquittal because they said that the questioning was suggestive and therefore it wasn't true. And,
oh yeah. There's so many like little rules.
So because of that, we take those interviews not everyone is qualified to do a forensic interview of a child. I have seen adult interviews. I believe the adult interviews are also recorded, but there has to be some sort of consent, either written consent or something like that. I'm not aware of what. It varies from center to center, I think. So
yeah, this is my experience in Northern California and then here in Southern California. So just California, and then on top of that, I haven't ever gone to one where like the law enforcement officer recorded the interview for an adult. That's just the one. But they've recorded like everything that they're saying in other manners, or like they've tape recorded them. Yeah. But I've never seen them actually like videotape them. But I have seen them do it with the kids.
Yeah, the videotaping is done. Usually here, the ones I've seen are done by the centers themselves, like the Santa Monica Retreatment Center or the East LA Women's Center. I don't know if you guys interview them, or videotape the interviews, but they're the ones that record. The officers are not usually in the room. I don't think I've ever witnessed one where the officers are in the room, but I know that officers will monitor what's being said, because oftentimes there might be somebody they're holding to figure out, do we have enough to arrest? So they have to be actively listening to what's being said, because maybe they don't want to interview the victim out on the street, so they just drive her over to a center where it's more comfortable for them. But they don't know what to do with this suspect, right? He's sitting in the car. What do we do? Do we arrest him? Do we take him to the station? So I actually have been involved in this situation where we are sitting there listening, trying to figure out, do we have enough to even arrest, or do we have enough to, ultimately file charges? Because when somebody gets arrested, we have a limited time to actually file charges, okay? And we'll talk about that in a little bit. Keep in mind that nowadays, some of the interviews, adult or children, are also being recorded because we now have body cams on the police officers and dash cams. So there is recording going on anytime. Now I think most of the departments in LA have body wire on. So keep in mind that those interviews are also being recorded through the officer body cam. And they just have them on them all the time, 24/7. And those videos are also limited. It's not like we're sitting there out there giving it to everybody, what's being said. I can only access that through a special program, and I have a special log. It gives, I have to ask for that particular time period or that particular police report period specifically after the detective, goes through it. So it's not like we just sit there and disseminate it to everybody, okay? So it is protected, but be aware that that could also be something that's being recorded and later used in court, okay? Any questions about that? No? Okay, feel free to. Okay, so we have the interview, the forensic medical examination, and you might have nothing else after that, okay? And if that's the case, please tell your victims, survivors, that this may not be the end. We have oftentimes contacted victims a year later, 10 years later, 20 years later, okay? Maybe we can identify them through DNA 10 years later, and then we contact your survivor then, okay? So it's not over, though it may feel like it's over for her, but it, you know, at least encourage them that they've done the right thing. Hopefully we'll get the perpetrator. They may not hear from anybody, but that could always happen, okay? So we move right along. If there is a suspect, if they do, we know who it is or suspect who it is, and we have enough evidence, probable cause, then there's an arrest, okay? So after there's an arrest, if it's an immediate custody, that process is going to be a lot faster for that victim than when there's a report, just, you know, somebody going to the police station or something like, or a delayed reporting. That's going to take a lot longer, okay? And why is that? When you have immediate in custody, you cannot keep someone arrested without formally filing charges within 48 hours, okay? So we have to make a decision right away. So the clock is ticking. We got to get it in. We got to resolve it. Are we going to file charges, yes or no? When we have a situation of delayed reporting or a situation where there's delayed reporting or something like that, then it has to get assigned to a detective. That detective might be handling, you know, 20, 30 other cases on a day-to-day basis, and they're not going to get to that report right away, right? There's no immediate, we got to stop the clock, we got you know, stress here, okay? So that may be the difference. So you might have people that come and say, I know somebody and they arrested the person right away. How come my case, nobody's doing anything about my case? Understand that's the difference, okay? Any questions about that? Okay. So we have an arrest is made that has to be brought over to the DA's office. We might not have enough time to investigate everything because of that clock ticking. So when I conduct the pre-filing interview of your victim, there might be a need to do further investigation. Okay. So prepare your victim for that. Hey, we're just going to talk to the DA. She's going to see what we need. Could we have enough? I might still need, hey, let's wait and see what happens with that DNA result. Let's get that toxicology done, okay? And we won't do anything with the filing until that's done, okay? If that occurs, the suspect gets released from custody, okay? It's not something we take lightly. It's not something that's fun to tell the victim about, but certainly if I have a victim and that's going to happen, you definitely want to warn that victim, okay? Because you don't want her to feel like all of a sudden I'm walking down the street and there he is. And we have had situations like that, so that could be very scary. And you know, we want to at least give some notice that that might happen. But that may be the reason why. We might need more investigation. It might take more time. We might not have enough evidence that it's this guy, not another guy. So we might need to wait for that DNA evidence. Okay.
If the suspect is released, is there any like measures the police department takes to keep the survivor safe? Like, I don't know, have like a police car outside their house or something.
Yeah.
I don't know.
No, we really don't have it. I mean, usually they can do an emergency protective order, but that expires after 3 days. It's just a temporary protective order, and then she or he would have to then go to the civil courthouse and get a restraining order yourself. At least it's a piece of paper that says, hey, you're not supposed to come close to me. As far as getting additional protection, that's not always the case. What we do have is the Victims of Crime program, and they will help with getting either some relocation funds right away to help them move so that they feel safer. And that's also an emergency basis, but it may not be as quick as we always would hope it would be, because it takes time to get the application processed, but it is an option. That's about it.
The other options would be like moving them to a safe house, so a shelter that's either domestic violence or sexual assault, because they're in confidential locations while this is happening, while this person is, we've done that before where, you know, while the person is, they don't have a restraining order against them and things like that. But safety planning is like the biggest thing there, right? That's when we would talk to them about like, do you have to stay at your like location? Can you stay with a family member? Can you stay with a friend while this is going on, right? Or have somebody stay over with you, vice versa, right? So there's more people who can notify. And there's the VINE, right? That's what it's called, which is essentially like, it's like a notification system with our prison system in California, where you can put in essentially what your report number is, and then they'll give you updates on whether or not this person made, you know, probation, made bail, and they're going to be released. So it's like an instant notification program.
Yeah, I mean, all we can do from our point of view is give them notice, explain to them. We have an advocate in our office who will walk them through the VINE program. What do you have to do to register yourself for the VINE program? Or what do you have to do to get victims of crime emergency funds? But other than that, that's where you might come in and like she said, make that offer of getting some shelters, temporary shelters, or some safe place where they can be until maybe there's either a filing or, you know, until they feel, I mean, you can move somebody and they still don't feel safe. So it's going to take a long time to make somebody feel safe, but hopefully working together, that's going to be faster, okay? So that's if we don't file charges. We could file charges, have the person arraigned, and that person can make bail. Okay, so what is bail? Bail is set by statute. So if you commit, for example, rape, the bail by statute is $100,000. That perpetrator can pay 10% and then put up the rest by bond, going to a bond person, and that means that they're making a promise that the person will show up to the next court appearance, and if he doesn't, then, you know, whatever they put up as collateral, maybe a home or something like that, the bondsman can then go get, you know, try to recover it that way. Or the bondsman makes a promise that if he doesn't show up to court, that they will go out and make sure he comes to court, because the bondsman is the one putting up that money. So, you know, that may occur as well, and that's why the VINE program is really important. If they make bail at midnight, I'm not going to know about it. I'm going to be asleep at home, and so is the detective, and so are you. So what if the guy gets out and goes and finds the victim, right, at whatever time of night it is? So the VINE program allows the victim who registers on that program to immediately get a call to say, hey, he's getting out in the next hour, so that at least the victim can then maybe try to, you know, move or something, or at least go to a safe place. So if he's arrested, we have 48 hours to bring them before a magistrate, and that's where you have what we call an arraignment. Okay? An arraignment is just a formality. Nothing really happens there, you know, from the victim's point of view. But it's a very important part of the process. It's what initiates the commencement of that prosecution. Okay? So when I file charges, those charges are then presented to him via a piece of paper that says complaint, and they're notified what is the charge, what is the maximum you're looking at. It gives them a breakdown of the minimum and maximum, all the other notifications and warnings that are done in writing to present it to the person charged and his or her attorney. Okay? So a lot of victims may get upset when they go to court on the arraignment date and they hear that the guy says not guilty, okay? And they might say, what do you mean he's not guilty? He confessed, he did this, there's all this evidence. How could he say that? And the answer is that, you know, it might be his attorney who's recommending that he pleads not guilty, but it's certainly for us, it's just a formality. The not guilty plea is the initiation of the process. Even if he wants to plead guilty at that point, no defense attorney in their right mind would allow that, because they would be disbarred, right? They have to look at the reports, they have to see what the evidence is. They would never just plead guilty right off, you know, on the first day. So that's why I kind of laugh and says pleads guilty, because that happens. Most of the time it's pleads not guilty. The bail is set at that time, and the case then begins from there. Usually there's going to be a preliminary hearing set, or there may be a preliminary hearing setting. What is a preliminary hearing? Preliminary hearing is where we go before the judge with our victim and we tell that judge the brief facts of what happened or what we think happened. It's not a full-blown jury trial, but your victim will have to testify at that preliminary hearing. And although it's not a full-blown trial, it's going to feel like that to your victim. Because you're going to have to go into details. You're going to be in a courtroom. Typically, a preliminary hearing courtroom has tons of people. They're coming in and out. You have officers there on other cases. It's kind of like going into this complete chaotic room. And somehow we have to protect our victims through that chaos to allow them to be in a space where they can talk about what happened. And that is very, very hard to do, but we do our best given that circumstance, okay? So the preliminary hearing is very, very important. First, from the judicial point of view, you know, the judge has to, you know, decide, do we have enough evidence? We can't just go around arresting people off the street just because we want to, or, you know, the judge has to convince, okay, there's a reason here to go to trial, right? It's not just up to me, it's not up to the cops. A judge gets that final determination. It's a check and balance on the power of the police and the DA, and so that's why we have it from that point of view. From the prosecutor's point of view, from my point of view, it's a great way for me to kind of see how that victim is going to do in front of a jury. So there might be a lot of issues with trauma that might be affecting memory. We'll find out how they do under cross-examination. Are they going to be too upset to talk about things? They've just decided they don't want to go forward. So it's a good test for me to see where we are in the case, and, you know, are we going to be able to prove this case beyond a reasonable doubt in front of a jury? It's not fun for the victim, but it's very important, yes.
How often do cases like die here at this stage?
They don't usually die. Most of our preliminary hearings get held to answer. Okay, very few, and I'm talking a very small number, do not. Because when I file charges, I usually will have done a pre-filing interview. So that is also another way that I can see the person. We talk about the person. I ask the questions. Okay, well, this happened. Explain this, and we test the memory. You know, so I already have a pretty good idea before I even get to the preliminary hearing. But the preliminary hearing, I may not expect that the defense might come up with something that I'm unaware of, and that, you know, may impact the way the case goes. But the case usually will not get dismissed at a preliminary hearing. It's usually held to answer, which is the formal way the court says you have enough evidence here, okay? But if we have some problems, or I perceive some problems at the preliminary hearing, then we'll start talking more seriously about disposition. This might be a good case to have a disposition on. We start talking to our victim about that, like, hey, how do you feel about this and that? You know, we start talking disposition at that point.
So I guess to back up one, how many around roughly, right? How many cases that you get presented to you do you actually take to this stage?
Pretty much every case goes to prelim. Very, it depends. Most of the time, it's hard to give a number. I don't want to throw out like a percentage or anything like that because I just don't do that. I don't keep track. But we try, especially on these types of cases and with children cases, to have a disposition before having them testify. So if there's a way to dispo a case without having to have that person testify, we will. But what I'm seeing now more and more is that's becoming very, very hard because the defense bar is fighting us on anything that's registerable as a sex offender. We're not going to be coming to, we're not going to come to an agreement. So most of these cases now are going to prelim now. So if you had asked me that question 5 years ago, I would have said we don't go to prelim that often, but now I feel the exact opposite. We're going to prelim on all of our cases.
Sorry, what's a disposition?
So a disposition is where we, the defense attorney and the prosecutor get together, we talk about the case, we know what the numbers are. For example, you have a 288A, which is a child abuse case, a sexual contact with someone under 14, for example. That carries a minimum of 3 years, 6 years, or a maximum of 8 years. Okay, or the other option would be probation. Those are our options, right? We can't just keep someone for jail indefinitely. These are our options depending on what the charges are. So I'm just giving you an example. So depending on the facts or on the evidence, we might think, okay, you know what? We believe this happened, but we might not be able to prevail at jury trial, so we'll offer this person probation or low term, or you know what, this guy has a really bad record, and we think he's really dangerous, so we want to offer him the max, okay? Defense attorneys may, even on an offer like that, like a max offer, okay, may know how great they'll have evaluated the case, they know how good it, maybe the crime's on video, I mean, so they're going to say, hey, can you do this for my guy? He doesn't have a record, or whatever the considerations are, okay? So when we say disposition, it just means, okay, we're making an offer for him to plead guilty in exchange for this lesser charge than the maximum, okay? And that way, we don't have the victim have to go testify, and usually we wouldn't make the offer until we consult with our victim, right? About, hey, I know you're probably pissed off that we're going to be talking about probation, but here's the reasons why. And we talk about why we may make an offer of probation. And if they agree, great. If not, we can talk about it. Ultimately, we make the decisions, but we always have input from our victims. So I haven't had a situation where, after we talk about all of the factors and all the reasons why, where there's anything beyond that. But we can certainly talk about it, but yeah. I mean, it's especially hard to tell parents whose children have been molested that we might be offering something like probation or 3 years, and they're like, what are you talking about? But there's very, very good reasons why, depending on our cases. And no case is identical. Every case has to be judged by the unique set of facts, circumstances. We might have some issues with a child who does not want to talk about, anything. So we might have to make those hard decisions. Okay, that's what we mean by disposition. So that is what we're doing at the preliminary hearing setting conference stage. That's sort of talking about it. Okay, hey, is your guy going to be willing to take this, or or what do you think this case should look like at the end? That kind of stuff. So if we cannot come to that meeting of the mind, if we cannot come to an agreement, we have the preliminary hearing. At a preliminary hearing, your right of your victim or survivor is to have a person of support, 1 or 2 people who can, of their choosing as support people. Okay. that's up to them. But we usually ask up front if they want to use a person who is a support person, because if the support person is also a witness, then we have to litigate that with the judge. Because the defense can object, and then we have to say, well, she has a right to have this person of her choosing as a support person. But then we might have to take some measures to try to minimize any kind of perceived bias or anything from that victim, from that witness at a later time. So an example of this is, let's say there's a child who's sexually molested, the mother is a witness, maybe the mother saw something and called the police, and now that child is there to testify. Well, obviously the child wants his or her mother as the support person, but what kinds of challenges does that cause us? What is that, what do you think that, what?
Bias.
Bias. Maybe the mom is gonna tell them, go change your answer. Maybe like there might be some coaching going on, some what? Some influence, right? And then maybe that mom who thought something was different hears the child may then change her own testimony, right? So the defense is always going to say, no way, she can't be in the room. We exclude all witnesses during the hearings, right? Because we want to make sure the witnesses don't start just all agreeing on everything. Okay, Gigi, where are you going? Come over here. So that's something that we have to get through. We will get through it, but just keep in mind that that is an issue then that I have to deal with when we have support people in the courtroom. Okay, it's usually not a problem, but we have to, have to go through the process of explaining to the judge how we can do it. Most of the time, the judge will say, okay, fine, have the mother testify first without the child in the courtroom, and then put the child with the mother, right? And then we give very, very strict instructions to the advocate, to the parents, whoever that support person is, that they're not to make any facial expressions, no commentary, no nodding of the head, okay? Because the moment you do that, what's the defense gonna do? Objection. I just saw that advocate nod her head up and down, telling her what to say, what the answer should be. Objection. That witness is being coached. And it is so hard to sit there and just be a statue when you have someone who's crying maybe, or may fall apart. Just the simplest, like, is it going to be okay? That can become an issue, for the court. So be aware, as an advocate, if you're going to be up there, you're basically not to have any contact, any facial expressions, no movement of any kind that could be perceived. And believe me, the defense is looking for those types of issues to put on the record, okay? So I actually prefer our support people not to be behind them, because they can't even be anywhere they can be seen. They're just behind the victim. And sometimes that's necessary. I understand sometimes you've got to be back there just so that that victim can actually talk about what happened. But what I like and what works just as good is to have the advocate here, right at the line of sight. Because then your victim's looking at someone they trust, someone they know, someone that they feel comfortable with, and the defense attorney is, has the back to them. So it makes it a lot easier. But those are things we talk about before we even start the preliminary hearing. Okay, before the preliminary hearing, I take all the time in the world to go over what's going to happen, where you're going to sit, what kinds of questions I'm going to ask. We talk about, hey, I know you want your mom and dad to be in the courtroom, but are you really going to feel comfortable talking about this in front of your parents? Right? Because most of the time it's easier to talk about this to complete strangers than it is to talk about it to your loved ones. It's not easy. But so we talk about all that before we even get started. Okay? And that's where you're going to come in. You're going to, sometimes I don't even want to ask that question in front of the parents, because sometimes I have teenage girls who will say, no, I want my mom and dad here, and the parents are there, but the moment they leave, yeah, no, I don't really want to talk about this in front of my parents, right? or it could be an adult person, whatever. So I always leave that as an audible at the last minute. Okay, tell me how you feel when we enter, because they could change their mind. Like they could think, oh, I do want my mom there, you know. So we always kind of wait for that last minute. Don't be so pushy about like, I'm your advocate, I'm here, I gotta do this. You know, let's just kind of wait and see and look at the dynamics of what's happening, okay? All right, so we have the preliminary hearing. The judge hears what happens. Usually at a preliminary hearing, I'm not gonna put on all the witnesses that were at the bar or people who saw them or anything like that. I might just put on the victim and that's it, okay? After I ask questions, the defense attorney asks questions. And usually that's enough to get the case held to answer. And like I said, I've already I already know what my strengths and weaknesses are on the case. We're just kind of testing the case at that point. So the court says, okay, there's enough evidence, and then we move on to another arraignment now in a new courtroom, new judge, who now is going to sit through the pretrial parts of the case, where we have motions. We talk about pretrial dates, what's going on. We might talk more disposition. Okay, now you've seen the victim, and she's really credible. Like, you better plead guilty, or else your guy's gonna get the max. You know, that's where we start doing that kind of conversation at that point. Okay. So you might have your survivor call and say, I haven't heard anything. The prelim was like 5 months ago. I don't know what's going on with my case. Just keep in mind, there's probably not much going on from their perspective. There might be a lot going on from our perspective. We might still be getting those toxicology reports. Hey, you know, maybe we've requested phone records, or maybe we requested surveillance tapes, and we're now getting them in, and we're having to share them with the defense so that everybody can be ready to go to trial.
And at that time, is the survivor in that particular courtroom, or is it only on the
no.
preliminary?
Great question, yeah. I don't tell your victims that they're probably not going to be needed at most of these hearings. There might be 10 hearings that we go to where they're not going to need to go. Usually they're going to get subpoenas, but you check with the DA or the detective before they take the day off from work or school, because most of the times they're not needed in those hearings. At pretrial hearings, they're not ever subpoenaed, and they're not needed in those situations. But obviously, they can call, they can find out, hey, when's the next court date, what's happening, are we looking for discovery, what's the deal, have you talked to my friend who says she was there and she saw this, this, and this. You know, those are the types of questions that we may be getting during this period. And no, they're not needed in court, yes.
Can they go to all those?
They can. All of these are public hearings. Anybody can go. Sometimes I have parents that go to every single one. Okay.
Or like their support person.
Or their support person can go. But, you know, parking is expensive. It's not easy to take time off work. It's not easy to be at every court hearing. You might get there at 8:30 and we don't call the case till 11:45 or sometimes 1:30. So yes, it is public. I would never stop you from going, but keep in mind that you might be feeling like you're wasting your time. And if you do go with your victim, let me know, let the prosecutor know that you're there just to see what's going on. Because I've had situations they don't tell me, and I have tunnel vision. I'm going in, I might have 10 different appearances that day, or not 10, but 5. Like tomorrow I have 5 court appearances. So I might be just going there, I'm talking to the judge, I'm talking to the defense attorney, we have a hearing, and I won't even know that I have a mother in the audience, right? So just give me a heads up if you're going to do that. Let the DA know, you know, or you can tell them, hey, I'm here on that case. So if you don't know who the DA is, they can point him out. Okay, when they come in, I'll point him out to you or something like that. Okay, so at least you have that more personal explanation of what's going on, or you know, because sometimes there might be discussions going on, but then on the record, when you see, you might not see very much except just picking another date. Okay, so if you're going to go to court, be aware that those are the issues. You might be waiting a long time. We might have already done the case and you didn't know it. Maybe you went to the bathroom or went to the snack shop, and we did it because we didn't know you were there. So please let the DA know they're there if you do decide to do that. So oftentimes before trial, we have a disposition at this point. The person might plead guilty at that point, and if that's the case, we always notify, the victim has a right to be notified of that, be notified of what that disposition is. She has a right to be present, he or she, so they could see the guy like saying, I am guilty, or no contest. Like that could be very, very important for their ability to get, to feel like, they've gotten some justice. And then we have a sentencing, and they have a right to be at the sentencing as well, and also to give a victim impact statement, which is where they can write down, they can say, they can, tell the judge, you can write a letter, do whatever. Sometimes they write something for me and I say it in court. This is their time to say whatever they want to say. It is the hardest sometimes to sit through. It's very painful. You watch people and what they have to say is very, very emotional for everybody. But there's not going to be any reaction. The judge cannot react. I cannot react. We might leave and then go cry with them, but we can't cry in the courtroom. Okay, so you're there. You can do that. You can help them. Sometimes you have to just help them with just holding their hand while they're reading this statement, or maybe they just talk from their heart. Okay, so. Yes.
And then just mentioning too that the victim impact statement is a really crucial part. Like
That's
if this
part.
person is convicted and everything,
Yes.
this goes in their file. So when they're up for
Yes.
probation and stuff, that gets to be reviewed
Yes.
as well. Like how this person's crime impacted that other person's life.
Yeah. So let's say the person gets sentenced to life. So that means they're gonna be up for parole every 7 years. So if you have a victim impact statement that's part of the record, when that prison board looks at that individual and decide whether or not they're going to parole him or her, they're going to say, oh, this is a victim, this is how it impacted this victim or this community or the friend or the family of the victim or something like that. So they have to consider that as well. So it's important that it's just part of the record. It's important emotionally for that victim to put in words what has occurred and how this has impacted them. And believe me when I say it's just, I've sat on some of those and it's just heart-wrenching, but very, very important. And you guys will definitely, I encourage you to go to them if you do get to that point, because it's just, it will give you that reason to keep going when it seems like this is a hard job. Okay? All right, now, if there's no plea agreement, then we go to trial. Just because you go to jury trial doesn't mean a jury is going to convict sometimes. Okay, we go, we think we have a good case, and then the jury hangs or the jury finds him not guilty. Okay. Very, very hard on us personally as prosecutors, because for example, I take every case personally. I don't eat, I don't sleep, but when you're in trial, you really are putting your best efforts into convicting this person, and we can fall short. Okay, so back when I do a pre-filing interview, I tell all my victims, hey, I can't guarantee a result. You can do this for 4 years, and we might go through all of this. You came to court a million times, and a jury might find him not guilty. A jury may not be able to make a decision, but I can't guarantee that result because I don't control that, and it's just random. A jury is picked random. We can just get unlucky and pick 12 unreasonable people, right? Hopefully, they're not all unreasonable, but that's what we're stuck with, right? So prepare your victim for that. It might take a long time, and if you do it early and you tell them as we're going along, and if we go through all that and that happens, at least they understand, hey, I did this not because I'm looking for a particular result. I did this because I stood up for myself and I took a stand. And I think that's just as important as whatever the outcome may be. What I can guarantee is that I'm gonna work really, really hard, and so will the detectives, but I cannot guarantee the result. Yes?
And the fact that even if, let's say, he's found not guilty, just the satisfaction of knowing that he has a record.
Right. It will be on his record. Somebody else might come. I have had cases where, I'll give you an example. I had somebody who was accused of raping her while out. It was an intoxication case in New York. He was acquitted in New York, and then he came out here, and then we had something similar happen again. So I was able to use that victim to come here and testify about the facts of that case to show that, hey, this isn't just that he said, she said, and people got mixed signals. This is somebody who's a perpetrator. And so ultimately, I mean, we brought in different women in that case, and he was ultimately convicted, and he's now serving life. But that first victim had a very difficult time because she had to go through that process of, I went through all of this, and he was acquitted in the end, right? But the end is not the end, always. She felt, years later, she got the satisfaction of coming once again, and this time having her believed, and also having this guy convicted. So it is very, very important no matter what. So I'm a lawyer, so I always prepare for the worst possible options. May not be the nicest way. Maybe you can be different in that sense. Like, I always have to think of all the things that could go wrong in a case, but I would not be filing a case or going forward with a case unless if I didn't really believe in the case. So keep that in mind as well. If the person's acquitted, they get released if they're in jail that day, that minute. And at that point, the only recourse that a victim would have would be to seek a civil case. Okay, I'm not a civil attorney, but that might be another option if we get to the point where there is an acquittal or there's no filing. Maybe the DA didn't file her case. There's always that remedy as well in civil court for that victim. And for that, they're going to have to get an attorney, a civil attorney, or maybe there might be some organizations that provide free legal services for the civil court. But that's not handled by the DA. That is a civil matter. So civil court is about money. Criminal court is about putting somebody in jail. Okay? So in civil court, it's a lot easier to prove your case because you don't need to prove, you don't have the beyond a reasonable doubt. You have just preponderance of the evidence. So like if you think 51% he's guilty, then that's enough for a civil judgment. So it's a lot easier on the victim than it would be in criminal court. Any questions about that? No? Okay. All right. So those are the types of things. Now, if you're going to have a victim that wants to sue this person civilly as well as a criminal case, that is perfectly okay. But let the DA know. And most of the time, and I think civil attorneys will also tell your victim that, they will say, hey, let this criminal case go first, because what is the first thing a defense attorney is going to say if they know you're also having a civil lawsuit? That you're lying because you're just trying to get money, right? So I would never stop a victim from seeking her right to get a civil case going and start. I would never do that. Of course, I want to be aware of that so that when they get up there on the stand and they're cross-examined about that, I would be aware of it. But keep in mind that that's going to be something that they will attack her credibility with by saying, hey, she's just doing this because she's trying to get money. And that case that I told you about, the guy was from a wealthy family. So one of the girls had actually her case was declined. It was not filed. So she went after him civilly and got a civil judgment. But then when we had another victim come forward, we were able to put them all together, and that's why we were able to get him, put him away for life. But in that case, that obviously became an issue when it came to her, because that is always a defense. A common defense, obviously, is that they're lying, that they're motivated by money or a civil lawsuit. We're getting a lot of defense witnesses or defense arguments about they're doing this for a U visa, or they're just making this up because maybe they're mad at this person, or maybe they are scorn lovers, or something like that. There's always going to be some theme that the defense is going to pick up, but prepare your victim for those kinds of attacks, but there's nothing we can do about them as part of the process, and hopefully a jury is going to see through those kinds of attacks. Any questions about that? No? Okay. If there's a conviction at that point, that means he's found guilty by either a court or a jury. And at that point, we have a sentencing hearing. And the sentencing hearing is where they do the victim impact statement. And the judge then considers, is this a probation case? The court will, if there's a trial, the court decides the outcome. So we might have a case where the maximum is now 20 years. We've had a trial, the jury found him guilty. The jury doesn't decide what he gets, what the punishment is. The judge decides at that point, right? So I only have input to what the punishment is if I have an agreement before we go to trial. But once we're in trial, it's all in the hands of the judge. So if that judge wants to give the guy who now we think is a 20-year case and he should get 20 years, he might give the guy probation. So this is where your victim impact statement matters, because hey, that judge is going to be up for election. Do they really want to give a guy probation that really deserves 20 years that rapes somebody? So this is where you, the advocate, can be really helpful in that. Bring your victims, bring the family, bring the community. I've had victims call like the local newspaper, right, to make sure that judge is on notice that hey, we're here, we're representing the community, and we're watching you. Okay?
How often are the judges on election?
Every 8 years. So they are first elected, or they can be appointed by the governor, and then after 8 years they're up for elections. I'm sorry, 6 or 8 years, I'm not sure. I think it's 8, right?
I think it's 8. Let me
Yeah, I think it's 8.
Research and online and find out like for a particular
Yeah.
judge?
You can look up judges are on the LASuperiorCourt.org, I think it is. They're all there. Jurors have there's Yelp pages on your particular judges. So it's amazing what people can find out about judges. I don't look up that stuff, but you can, especially if you're way better at the computer than I am, but I'm usually too busy to do that. But I know who my judges are. In my particular building, most of them I've been in front of, so I'm aware of what their strengths and weaknesses are, and I usually can warn our victim of that. Like, hey, you know what, we have a really good judge for this type of case, or, this is going to be a little bit hard, but, we're going to fight. So, who knows?
It's 6 years.
It's 6 years, okay, yeah, 6 or 8.
It's an even number.
Half a dozen.
And, don't even get me started. I used to think judges knew everything. They were so smart. Oh, my gosh. And now the longer I've done this, I realize, like, oh, my God, most of them just donate money to the governor or something. That's how they get appointed, but that's a whole other subject. I don't like all my judges, but anyway. So it would be up to the judge if he gets state prison or probation. And it depends on the charges. I tell my victims, hey, for this case, we're not going to get the death penalty. I know you think we should get the death penalty for him molesting your kid, but it's not a death penalty case. Like, there's only so much that we can do. Like, hey, the maximum we can get is life. That's it. Like, I can't do more than that. And I know it sounds like I'm being, facetious about it. I'm not. I've had victims get upset that the defendant only got 40 years to life, okay? Like, there's not much more I can do at that point. And so what that tells me is that you have to work at that point as an advocate really hard to get through that anger, or maybe that was, that's an issue then, that I'm sort of gonna not be able to help them with. Like, there's only so much. Once we get them access, there's not much more we can give our victims. I can't get the guy hung. I have had parents tell judges during sentencing, hey, that person should be hung and burned. And the judge had to say, like, sorry, we can't do that. That's the only way I'll feel justice. We have had people say that in court. And I understand why they're saying it, but this is where you as advocates can maybe help, like, hey, let's get some more therapy. Let's figure a way out so that you feel you have justice. Because in the end, we're doing all this for them, right? So if they're not feeling like they're getting justice, there's a problem. So, that's something we can work with, hopefully, after even the sentencing.
And hopefully during this time, they will be getting counseling
Yeah.
there at the agency. So that's also gonna be helping them, because they'll be coming in and speaking to a counselor and, working their feelings out and their emotions in regard to what has happened.
Yeah. And we get it. I mean, I had a preliminary hearing not too long ago. It was actually a male victim. And when he saw that it was two guys that assaulted him, and he was in court, like, the whole time, he just wanted to jump off of the witness stand and go pick them up, right? Like, he was so angry, you could just feel it. It caused us to go, that prelim went on a lot longer than it should have, because we had to pause. At one point, the bailiff had to warn our victims, like, hey, I'm gonna have to arrest you if you keep doing that. Now, from my point of view, I get it, I understand, I don't blame him, because he went through, he was really tortured, but we have to have some, decorum in the courtroom of civility, and, there's rules, and obviously it got to the point where he had to be warned that he was going to get arrested. So on something like that, that might be a case, and I'm thinking, well, maybe this isn't a person that's going to come off well in front of the jury. The jury might not like that, because they might think he's the aggressor. Maybe not, I don't know, but on a case like that, after I saw that, I may now want to find a way to find a resolution. Because and the defense was poking and poking and poking. They knew what they were doing, and they were just making him more upset.
So what determines a case receiving that amount of time? Because normally when I hear of rape or sexual assault cases, the person only gets 6 months to a year.
Yeah. Yeah, so
And then
great question.
Most times the bill is not even that high. And
Yeah.
They get out sooner than 6 months.
Yeah. Okay, so that's a great question. It's not an easy, simple answer, and we're going to talk after the break about that, but I'll just give you an answer really quickly about that. It depends on the charge. So, for example, if I have one count of rape, which is the 261A2, and we'll talk about it, you'll see the link here. That's only a maximum of 8 years, minimum of 3 years, and the guy can get probation. Okay, if it's filed as a felony. I'm not aware of, you said 6 months, that means that it would be a misdemeanor. I'm not aware of a rape charge that comes with 6 months, because rape, the legal term rape, is a felony and is punishable by 3, 6, or 8. And the bail on a rape would be $100,000, okay? But there's many, many exceptions. So for example, if we have somebody who's been tortured, or somebody who commits rape after he has a conviction already for rape, then we can go into what we call the one sex strike, which is where the guy's now looking at life, 15 years to life or 25 years to life. So it depends on a lot of factors. If the person was tied and bound, was there a gun used, right? Because then if there's a gun used, then we have the gun, which carries 25 years. I mean, there's all these little nuances of what could add to our life terms. If we have more than one victim, like in that case that I told you about, because we have so many victims, that elevated the case to 15 to life. So one count of rape is only $100,000, it's only 8-year max, but if I have 2 rape victims, or I have some of those factors, like a weapon used, someone who has a prior conviction, multiple victims, it happened inside somebody's home during the commission of a burglary. Those factors are going to elevate that rape to a life or some sort of higher exposure, okay? So it really depends on what your facts are, and this is where I know that, it's hard to tell, when you're talking to somebody that say, this happened to me, it's hard to figure out from your point of view, is this a case that's gonna be a probationary plea or a life plea? It really depends. It depends on what our factors are, what we can prove. Maybe the victim says that there was a gun used, but we can't prove the gun. We never found the gun, there's no evidence of gun, so we might not be able to charge the gun, right? So those are the kinds of things that we're looking for, and by the time we charge, you'll know. So if I charge and I've charged some of those factors, when I talk to my victim, I'll explain to her, hey, this is his maximum, and we this is what the bail is, because if we have life factors, we're looking at over $1 million per count. So it really varies, but 6 months doesn't sound like it was charged as a rape. Maybe it was charged as a misdemeanor sexual battery, which would be a misdemeanor, and that would be 6 years to a year or something like that. So it just really depends on the facts. And look at it from our point of view. A case where you have somebody walking down the street and being touched over clothing, maybe on the genitalia or something like that, is going to be punished differently than somebody who's in their home, somebody breaks in with a knife or a gun and gets, where there's full-on penetration going on. So that's going to be the difference in your punishment. Like how severe are your facts, how severe are your factors, and what you can actually prove. Does that make sense?
Do you work very closely with police officers?
I do, yeah.
How do you, how quick is the response rate for them to actually come out? Because I had a friend like a week ago, someone tried to break into her house 3 different times, and like she feared that she was going to be raped, and she called the police. The police took about 25 minutes to come, and then when she said like, hey, this person went 3 houses down, they were like, well, we don't see the person, we couldn't do anything, so we just left.
Yeah.
And she just feels like, because especially as being a woman and the street women in the house, that, the police are just like, well, we can, it's just all these rules and these laws that,
Yeah.
you have rights, but then you don't have rights. It's like,
Well, yeah, I mean, from the cops' point of view, they respond to a call like, hey, somebody tried to break in, but we don't know who, they show up, he's not there. Yeah, you may have cops who are gonna be like, okay, well, there's nothing, we're gonna take a report and that's about it. So I had a case similar to that. Like, I had a case where a guy was seen trying to break into a lady's house by the neighbor. He shooed him away, and then he was trying to break into another house, and you saw the cops actually talk to him, but there wasn't any, they have to have probable cause to stop somebody. They can't just say, hey, somebody thinks that you try to break into their house and arrest them. Like, they have to kind of have something to go on, maybe like fingerprints or something like that. So they actually talked to him. They let him go. They didn't arrest him. And then 2 hours later, he broke into my 79-year-old woman's apartment, and he tried to rape her, and and now he's looking at, he's in jail, sitting there for life. Okay, so yeah, in that situation, the witness who had seen him talking to the police was very irate at the police because he felt that he could have stopped. They could have stopped the guy from going and assaulting this older woman, but from the police officer's point of view, it was like, hey, the guy said he saw him, but when we saw him, he was just walking down the street. We had no evidence of, what he was going to do or what he had done, so they didn't arrest him. They felt they didn't have enough probable cause to
or
arrest him.
not necessarily to arrest, but couldn't they can't you go and be like, hey, you look like a suspect? I mean, because cops have done that before.
Yeah, but then you get into the whole okay, cops are stopping me, and what are the reasons you're harassing me, you're profiling me, so cops nowadays are like, okay, I can't, even the consensual encounters are starting to be fought more, like you're just stopping me to, talk on the street, so it's really, I'm not saying it's always going to be a good outcome. More often than not, we have bad outcomes, and there's no arrest made. The person goes out and rapes somebody else, and then we get them. obviously, it would have been better to not have gotten him before that second rape occurred, but we may not be able to prove it, or whatever the case might be. I can't control what 10,000 officers in LA County are gonna do, I can only control what I can do, okay? So, and you can only control what you can do, like, hey, we have this victim here, make sure they take the report, keep calling the detectives, make sure they do something about your case, because they're looking at a pile of cases, and, you know, they have to do one by one. So if you call them, you might get them more attention, or get their attention faster for your victim.
But with that, it also depends on the size of the department and the priority of the calls too.
Right.
There's something, there's a robbery going on right now, they're all gonna
Right.
rush to that as opposed to a
Right,
burglary
maybe
happening
there's a gang
yesterday.
shooting or something, and then they have like somebody who's like, oh, I was, you know, this happened last week, they might not give that case priority than the other shooting that's going on right now. And I'm not trying to justify it at all, I mean, I think that we need more resources, but there's a limit to what the police can do. And I'm not trying to speak up for them, I think you're gonna have a police officer or detective come talk to you, so you could ask him that question, okay?
Okay, alright.
I'll tell, I'm pretty sure I know who it is, you can ask him that question.
Yes,
I hope that
Moses
answers,
will
I'm
be
not
here.
trying to, I'm just telling you, it's
No,
hard
I'm
to
just
know.
asking, cause I just know, you know, it's my friend, so she wants to find him and be in there, cause he's down the street.
Does he know, he knows where he is?
Well, he's living in a house, he's squatting in a house.
Did she
But they can't.
file a police report?
Well, no, they didn't have any evidence for
But she can still have a demand that they take a report, and then have, that case has to, if it's a report of an attempted, it's called, what happened to her is a 220, right? Inside her house where he tried to rape her.
Well, no, he didn't actually get into the house.
He tried to get into it.
He tried.
Okay,
to
so
get
it's an
into it.
attempted burglary, so she
Right.
can force the officer to take down her report, and then it has to go to the burglary table, and they have to do something with it, either follow up and not say there's not enough evidence, or at least take a report, they can't just not take a report, do you know what I
She
mean?
did.
Right, but tell your friend, if she's gonna do that and they arrest somebody, she's gonna have to go to court and testify, and sometimes people don't wanna do that.
Okay, she didn't do that.
Well, don't have her get arrested.
Well, yeah.
Okay,
But it's
so,
just interesting, because she did see him the next day, right across the street from her house again.
and that happens, and that's gonna happen to your victim. You might have that victim who, like, I was walking here, taking out the trash behind my building, and here's a guy that jumped over the fence and tried to take my clothes off, and I fought him off, and I called the police, nothing happened, and then sees him down the street, you know, a day or two later. So you're gonna have those situations, and hopefully you're gonna have a police department that's responsive, and I'm not, you know, again, there's police departments, and there's some that are more responsive than others, there's some cops that are a lot more responsive than others. So all you can do as an advocate is, you know, ask to speak to a supervisor, I guess, if
And
they're
then-
not being, getting
Yeah,
back to
and then on that note, you always, if you have someone who's being stalked, or someone who's being followed, or someone who's being like, you know, someone is habitually doing things like that with them, you want them to make a log, a stalker, we call it a stalker log, right? And it's super important to document these things, like on a calendar somewhere, or in like a planner or something like that, cause that, correct me if I'm wrong, Gloria, but that can be used as evidence in court,
Yeah.
to help
Yes.
essentially corroborate the story, right? Like, I can prove to you that this was happening because I've been documenting
Yeah.
it. Like, there's no way that I would just, you know, make this up, like, because, you know, we ask people to have, like, little notes and stuff like that, for those situations. I know it sounds like more work on the person who's being harassed part, but you know.
And keep calling and documenting and doing everything they can, but I mean, hopefully it gets to the point where you're getting the attention of the police officer, so you
Right.
can provide them.
And doing things like that will make them take you more seriously.
Yeah.
Because again, like, you're showing evidence in that sense, like, that is a piece of evidence. Versus like, well, this person was here and now they're gone and I don't know
And you
what to
don't
tell
know
you.
when he was there, what he was, you know.
Descriptions of the person, if they don't know who the person is, if they do know who the person is, you know, like trying to get pictures and stuff like that, if they can do it safely. Letting a friend know, I also have people document it that way, like having, especially like domestic violence cases, when abuse does happen, they'll call a friend and that friend is logging things for them, right? Or they have somebody in their life that it can do that for them if they can't safely do it in their own home.
Yeah, this is the job that you can do, that, you know, you're right there, you're there with your victim, you can advocate for her, this is what you can do as the advocate, I think. in that situation.
Can we get copies of the report? If you need
Great question.
I've been wanting to ask them to you.
Great question. Okay, so yes, you can get copies of the report, but if I have a case, I'm not gonna want you to get copies of the report. And it's not because I'm trying to hide anything, but because again, what is my ultimate goal is to get a conviction, and I don't want the defense to say, oh, she got a copy of the report and that's why she knows what to say, or you know, whatever the case might be, you know. So, I know in DV cases or sex cases, we don't want the victim to read her own case, because we don't want it to be any suggestion that she's just kind of memorizing or, you know, or practicing her statement or anything like that. I prefer like for her memory to be natural, because people are not robots. I don't want it to sound rehearsed or anything like that when they're testifying in court. But yes, she could always get a copy of the police report. If the detective finds out about it, they might say, no, you can't get this report because it's a pending investigation. Maybe we're still investigating, so we don't want the victim to have that, or anybody, the defendant can get a copy of the report. So in that situation, we don't want the perpetrator to know what evidence we have, so we would not want to release anything that's pending. After the fact, absolutely, because she may need it for anything like a U visa or whatever the case might be. So yes, you can eventually get a copy of the
Oh, okay. So, how do you handle like, military cases that do not happen on base? Because I know if it happens on base, then they have to handle it. But what if, you know, the perpetrator is a military member and he's out in, you know, here in a civilian location?
Yeah, I mean, that's
How-
handled the same as
The
any other
same as any
cases.
other
Wherever the crime occurs, that's the jurisdiction that gets it. So you might have a situation where the victim was out in Santa Monica and that's where it happened, but she lives in East LA and is calling the East LA Women's Center. Well, the agency responsible for the investigation in that report would be the Santa Monica Police Department, right? Because that's where the crime occurred. Sometimes we can negotiate if the crime occurred in various different locations, or counties, you can negotiate and pick who has the best evidence and go with that jurisdiction. But for military cases, it doesn't matter that they're military, if the crime occurred when they're out on their free time and they're here in LA. I've actually had, cases where they're soldiers.
Would
The MPs do get involved because there's always, at least in the case I had, it was a female military person and a male military person, and she made the report initially to the military police department, and so then they made the referral to the sheriff's department here, and then we took up the prosecution of the military person. But the MPs were involved, because they took the initial reports and they had some statements that they could turn over to us, but eventually he was prosecuted here, in LA. But in those cases, once he was convicted, the military also has a system where they can
so
also,
they convicted out.
he also
here
was
and then
facing
convicted
charges.
inside.
After our conviction, he faced charges within the military and was looking at a lot more time in the military than out here. So that was interesting for me. I had no idea, like he was looking at 20 more years than a year in the military. So after we got done with him, he was prosecuted by that. Okay, so that's it for the criminal justice system. You're not here to be, experts in this. I wanted to walk you through that because that's what the victim is going to go through and what she's going to have to deal with. I was just at a conference about 2 weeks ago where we had a survivor actually speak as a keynote speaker, and she talked about that process, and it took 4 years. She went through she testified at the preliminary hearing and then 2 separate trials, because the first jury hung, and then the second jury hung, and then the case was eventually pled. And she talked about how difficult that process was. It's not easy. So, keep that in mind. Like, there's not always going to be that great, great result at the end where, like, there's this guy that gets convicted to life. That's not going to, that's usually not the case. In every one of these cases, we get a lot more reports that we never file on than the cases we do take all the way to trial. So it's hard on your victim. Time, emotion, it's very difficult, and you may not even get the result that they want. Okay? So keep that in mind when you're talking about, you know, you're helping them through this process. It's not an easy process, but it's a lot easier when somebody's there with them, okay? So let's take a break.